Hi everyone, and welcome to today's webinar, Environmental Claims and Legal Liabilities, a deep dive into anti-greenwashing regulations. So as always, I'll just do a little bit of orientation about the webinar platform before I introduce our speakers for today. The webinar slides are available to the left side of your screen, along with a few more helpful links if you'd like to explore more and learn more about how compliance and risks can help simplify and accelerate your compliance processes. And we do want this webinar to be as engaging as possible, so please send us any questions you may have, and we'll aim to address them during the Q&A session at the end of the webinar. And if you'd like to submit a question for this Q&A session, just use the Ask a Question widget on the left side of your screen. And we'll follow up with anyone who we don't get to during today's session. If we can't answer them directly during the Q&A session, our experts will reach out to you directly with an answer. And at any time, if you're interested in having a member of our team follow up with you outside of asking a question during today's session, just use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be sent to you within 24 hours. My name is Orla Morris, and I'm the Content Marketing Manager here at Compliance and Risks, and I'm delighted to be joined by Emilia Senza and Anna Shipanova. So Emilia is a Senior Regulatory Compliance Specialist with over 7 years of experience in the legal compliance sector. She joined Compliance and Risks in 2017 and is now a Senior Team Leader. As a Senior Regulatory Compliance Specialist, Emilia is keen to keep clients up to date on global regulatory developments, with a particular focus on her areas of expertise, which include consumer protection, textiles, as well as data protection. Emilia graduated cum laude with a master's degree in law at the University of Catania, Italy, and holds a postgraduate diploma in legal professions. She has worked for several legal offices in Italy, where she has gained extensive experience in private practice. Thank you for joining us today, Emilia.
Thank you, Orla, and welcome everybody. Delighted to be here today.
And moving on to Anna, who is a Senior Regulatory Compliance Specialist at Compliance and Risks based in Milan. Anna joined the Global Regulatory Compliance team in November of 2021 and is responsible for monitoring regulatory developments in CIS countries and helps clients with questions in relation to these countries. Anna is an associate subject matter expert for textiles, illegal logging, ESG, of supply chain due diligence topics, and also an SME for labelling of textiles and sporting goods projects. Prior to joining Compliance and Risks, Anna worked for 5 years as part of the escalation team in 2 of the biggest social media companies in the world. Thank you for joining us today, Anna.
Hi everyone, glad to be here today.
Brilliant. So before we officially kick off the webinar, I would like to just give a quick background about Compliance and Risks for those who are joining the series for the first time. At Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are the trusted compliance technology provider for the world's leading brands and have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape, proving your product's compliance, protecting your brands, and importantly, helping to drive your growth. At Compliance and Risks, we have the world's most comprehensive regulatory database with over 100,000 regulations historically available in C2P. With a global regulatory coverage and expertise across over 10 industries, we understand that regulatory compliance definitely doesn't sleep. And our regulatory experts team is truly global, with 28 languages collectively spoken across the team, all fortified by our 30 global knowledge partners. And as mentioned, C2P is our enterprise software designed to keep global organizations on top of regulatory changes and their impact worldwide. And this includes features such as early warning alerts, impact probability, productivity workflow tools, and so much more. And with that, I'm delighted to pass it over to you, Amelia.
Thank you, Orla. And thank you for the introduction again. And welcome everybody to all our attendees on this webinar, specifically dedicated to environmental claims and anti-greenwashing regulations. So what's on the agenda for today? We are aware that companies are really struggling to stay up to date with the new regulations, especially the new rules on anti-greenwashing, and are worried that they are not able to fully grasp the scope of the new requirements. So to navigate this complexity, we have structured this webinar with an introduction on greenwashing and the different types of environmental claims. Then we'll present key statistics and trends to also illustrate also how many countries are addressing greenwashing in different ways. And the idea is to provide you the main regulatory frameworks for EU and US. Then we will follow with US and Canada, and then my colleague Anna will give you an overview of some Asian country. So to give you not only an overview of the regulatory developments in those countries, but also examples with recent disputes to highlight how these rules are being applied in practice. So let's start with the biggest question. What is greenwashing? There is no internationally recognized definition of the term, but we can say that it is a misleading practice used to give the false impression of the environmental impact or benefit of a company's product, service, or operation. So it really could be any information, statement, communication regarding the environmental responsibility of the company, or also an information about the environmental impact of a product. I listed here some of the most common types of greenwashing. For example, we have green labeling, which is the practice of misleading information about products and their sustainabilities, for example, by using eco-friendly language, which is not substantiated. Then we have green lighting, which is the practice of highlighting a certain feature of a product to distract from other negative aspect. Green crowding, which is hiding behind group green initiatives, for example, being part of a green alliance with specific green objectives, when the single company instead is doing very little under this aspect. Then green rinsing, which is frequently changing sustainability ESG targets before they're even achieved. For example, becoming carbon neutral by 2025, but then changing again the deadline without even achieving the first. And then we have green shifting, which is shifting the responsibility to other stakeholders, for example, consumers, meaning, for example, encouraging consumers to recycle their products while the company is doing little in that front. All these tactics can mislead stakeholders, consumers, and are increasingly under scrutiny by not only regulators and enforcement authorities, but also civil society, in particular Consumer Protection Association and NGOs. So following from the definition of greenwashing, we can then infer that there are different types of green claims. There are, of course, claims about the performance of the product, about their sustainability characteristic, environmental characteristics. There are corporate environmental performance claims, which are instead about the commitments and goals in terms of, at company level, in terms of environmental performance. And future claims, which focus on companies' goals for the future, in particular climate goals or net zero targets. So it is really crucial to understand when a green claim can turn into greenwashing. And this typically happens when the claim is too generic or vague. So there is no possibility to know whether the claim is true or not. When the claim is misleading, for example, by overstating progress on sustainability or environmental impact of a product, when it is inaccurate or incomparable, so there are no data to understand how the statement is, what the statement is based on, and also there are vague data metrics that make it hard to compare. And also when there are some omitted information, so the claim highlight only certain positive effects, but ignores the harmful ones. I just wanted to show you this data to have an idea of how well or bad companies are performing so far. These data are taken from a survey by the EU Commission in support of the Green Claims Directive proposal. And as you can see from these numbers, there is still, the data showed a widespread practice of greenwashing, with 53% of the examined green label which were found vague, misleading, or unfounded, and also 40% with no evidence to back them up. On top of that, over 200 sustainability labels, and half of the green labels offer very weak verification. In the rise of greenwashing stems, in fact, from different factors, and the issue has gained increased attention for multiple reasons. We have, for sure, a shift in the consumer behavior. Several studies have shown that the consumers have changed their purchasing behaviors towards sustainable products, and they are willing to pay more for sustainable products. And companies are therefore reacting by setting harder climate commitments as part of their business strategies, and also by trying to make products more attractive to consumers from an environmental point of view. Investors as well and employees are of course attracted by companies with strong sustainability claims and credentials. So addressing greenwashing has become crucial to ensure consumer trust and also protect the investors. So far, the most affected sector, which have been under scrutiny, include the automotive sector and more generally transportation. Let's think, for example, about the green credential in terms of emissions of vehicles. The fashion industry, which is highly affected, and areas of scrutiny varies from, for example, supply chain green credential to product claims regarding the percentage of green materials, fibers in a product, or the recycled content in a product. Also, the energy sector, common cases include renewable energy use against the main fossil fuel consumption, and finance and investment with misleading marketing of investment funds as sustainable. Also, in the last 2 years, the consumer goods sector is facing growing scrutiny, also in consideration of the already mentioned increased consumer awareness. In terms of litigation, the rise of greenwashing disputes has been constant until 2023, while in 2024 there was a decrease for the first time in 6 years, but however, high-risk cases increased by 30%. The reason for the drop in 2024 could be linked to the growing awareness among companies who are more prepared and reacting to the new regulations. As in the past 6 years, the greenwashing incidents are highest in the US, in the EU, and North America. And this year, in 2025, there is an increased number of cases in the US and UK, probably due to the fact, as I said, that EU companies are more prepared, whereas the US and UK are a bit behind in this path. So now let's start to have a look at what countries are actively doing to combat greenwashing in terms of both new regulations enacted, but also in terms of enforcement. As you will see, there may be countries where despite the absence of new regulations, enforcement is nonetheless quite strong. So it is important to monitor this aspect as well. We can differentiate among three different levels of protections against greenwashing. We have countries where there are only the existing and current consumer protection laws or the competitions and trade regulations advertising rules, which are used to combat greenwashing now. Then we have level 2, where besides these broader regulations, countries have issued specific guidance documents to clarify how these rules can be applied for greenwashing. And then level 3 for countries which instead have enacted specific regulations. In the EU, as we all know, the process for a comprehensive framework is still ongoing, and the EU has set key goals in terms of carbon neutrality, circular economy, clean industry, and sustainabilities since the Green Deal in 2019. And so the EU is definitely at the forefront compared to other countries. And the ultimate goal of reaching climate neutrality by 2050 has served as a foundation to enact numerous policy initiatives and numerous legislation, including targeted measures for corporate sustainabilities and product sustainabilities. In terms of greenwashing, we have now two sister directives. The first one is the Greenwashing Directive, also known as the Empowering Consumer for the Green Transition Directive, which aims to ensure that consumers have reliable information about the environmental impact of a product. The scope is very broad because it applies to all companies operating in the EU market and to any business-to-consumer commercial practices. Basically meaning any act, communication, including advertising and marketing for the promotion, sale, or supply of a product to a consumer. As you can see, the deadline for the transposition by member states is the 27th of March. So it's quite close, and because the application date in each member is the 27th of September 2026. So far, only one state, Denmark, has enacted the implementing rules, whereas other 8 have issued their proposals. And it's worth noting that only one country, one member state, have enacted specific penalties in case of violation of the directive, which is Estonia. The others rely on the existing penalties under broader regulations and consumer protection regulations. So the directive introduces new broad definitions of environmental claim and sustainability claim, essentially applying to any form of label and communication. Any type of information given by text, symbol, images that implies that a product has a positive or zero impact on the environment, and also very broad definition sustainability label, meaning any voluntary mark that aims to promote that a product has a positive impact in the environment, and also regarding their social characteristics. The directive expands the list of unfair commercial practices by prohibiting generic environmental claims without demonstrating excellent environmental performance, meaning compliance with recognized eco-labeling schemes such as the EU Eco-Label. Generic claims such as green, eco-friendly are banned as they are too vague, and also claiming that a product is made with recycled materials could fall under this prohibition if it's not properly substantiated. Information on the display of a sustainability label is prohibited if it's not based on a certification scheme or not established by public authorities. Also, environmental claims about the entire product when it only concerns a certain aspect of the product is prohibited, and claiming based on the offsetting of greenhouse gases emissions only that a product has a positive impact on the environment is also prohibited. Presenting legal requirements as an additional features when they are instead imposed by law is also prohibited under the directive. The second directive, which is still in a draft form and the finalization of which is not certain at the moment, is the Green Claims Directive. As you can see from this timeline, the legislative process has been quite long, since March 2023. And we have now 3 different drafts from each EU institution. The trilogue negotiations among the EU institutions started in January, and then they stopped in June, when the EU Commission announced its intention to withdraw the Green Claims proposal, which was quite surprising and unusual, given that it was about the withdrawal of an entire piece of legislation which was under discussion for over 2 years. But that proves how difficult the legislative process has been, and with lack of agreement on several points of the directive. Then at the end of June, the EU Commission seemed to say that the directive is still on the table if an agreement on the exemptions for microenterprises is reached. On the 21st of October last month, the EU Commission published its work program for 2026, and the Green Claims Directive is included in the list of pending proposals. So it is officially on the table, and therefore this is definitely something to monitor closely next year. What are the main requirements under the Green Claims Directive? Claims must be substantiated with scientific evidence that is widely recognized, identifying the relevant environmental impacts and also any trade-offs between them, must be appropriately communicated, but the main point is that claims must be verified ex ante by third-party conformity assessment bodies. And one of the points of discussion was also the possibility of introducing a simplified verification procedure for simple claims, even though the definition of simple claim can be tricky. For example, a simple claim could be a claim not requiring a full life cycle analysis, or claims which are related only on a single aspect of the product. Other points of discussions included the maximum verification time, because of course businesses would like to have their claims out as soon as possible, and the transition period by member states, and the penalties. The penalty section was deleted in the Council's draft, whereas the other 2 texts had a 4% monetary fine of a company's annual turnover in case of violation of its provisions. Now I wanted to cover also a few EU member states, in particular France. France, as we know, has consistently led the way in addressing environmental liabilities, with several laws, starting with the anti-waste law for a circular economy, which bans the use of generic terms, such as environmental friendly or other equivalent terms. And also the Consumer Code was amended to include in the false and misleading claims also claims regarding the environmental impacts of a product or service, or also the scope of a brand commitments, especially in environmental matters. Also, we have the climate and resilience laws, which targets carbon neutrality claims. For example, a decree from 2022 bans the use of carbon neutral in advertising, without producing a greenhouse gas emission balance sheet covering the entire life cycle of the product advertising. As you can see, there are also high fines, which include also imprisonment of 2 years. And in May 2023, the French Ministry of the Economy published a practical guide regarding environmental claim, which is used as an important enforcement tool by the General Directorate for Competition, Consumer Affairs and Fraud Control. which is the enforcement authority, which has the power to identify breaches and also sanction with fines. In particular, in 2023, there was a major investigation by the director, and out of more than 1,000 establishments inspected, 1 out of 4 was found to be in violation. And many businesses, they brought them back in compliance by removing or changing their claims, but also the directorate issued warnings, injunctions, and 25 criminal or administrative fines. In June 2025, a 40 million fine was issued against a fast fashion company because the French authorities found that the fast fashion company was unable to justify the environmental claims made on its website, describing itself as a responsible company, and also regarding the target of reducing the greenhouse gas emissions by 25%. In October, just last month, another conviction, this time to a big energy company for misleading neutrality goals. 3 NGOs sued the company, which has been found guilty of misleading consumers by claiming on their website that they could achieve carbon neutrality by 2025. And also other statements on the website about being a big player in the energy transition, while actively increasing oil and gas production. So the court ordered to end the communication and also ordered to post the court's ruling on their website. Italy is another country where there are no specific greenwashing rules, but there has been a considerable increase in disputes. And greenwashing is considered an unfair business practice under the Consumer Code if it consists of a misleading marketing communication that might influence purchasing decisions. And the main enforcement authorities are the competition authorities and also the Institute for Advertising, which has also a self-regulation code which used during enforcement. We have a case from August 2025, again against a fast fashion company for misleading green claims. Claims highlighting the use of green fibers, for example, without specifying the substantial environmental benefits of these products throughout their full life cycle. And also statements on their website about the reduction of greenhouse gas emissions by 25% by 2030, which was presented in a very generic and vague manner. Another case in mid-July towards a mineral water company. Following the authorities' intervention, the company removed the misleading labels on their mineral water bottles and also on the packaging and on their website and advertising by removing green claims stating that the production of its green bottles had no impact on the environment and by withdrawing the zero CO2 impact from their communications. Moving now outside the EU, we have the UK, which does not have a standalone anti-greenwashing law, but in April, the new consumer protection regime entered into force, which strengthens the enforcement power of the competition and markets authorities. In fact, the authority can investigate directly without court involvement and also issue fines, which are very high, up to 10% of annual turnover. And we also have the Green Claims Code, which is used by the authority, again, to identify potential breaches. And as we said in the introduction, the UK has seen an increase in greenwashing disputes this year. We have, in July, the advertising authorities issued, issued several rulings against oil and gas companies regarding their low carbon investments advertising. businesses, the reason behind was that where businesses are responsible for a significant amount of environmental harm, with emissions, for example, any ad which focuses on environmental benefits is likely to be misleading if it does not include balancing information about the ongoing contribution of the company to that environmental harm. Also in 2024, CMA conducted an investigation against 3 fashion brands, which then signed formal agreements to use only accurate and clear green claims. And they're also required to report to the authority about being specific regarding the materials that they use, about not using misleading images, and support also this data with verifiable strategies and environmental targets. Stemming from that investigation, also CMA published a specific guidance for the fashion sector. Moving now to the US, the US is another country with no specific anti-greenwashing binding rules, but we have the green guides, which were revised in 2012, and then also a new revision process started in April 2023, but then this process has stopped and there are no further developments at the moment, but this is something to keep an eye maybe in 2026. The guides are not binding, but they are a useful tool for the Federal Trade Commission to determine whether an environmental claim can be found deceptive under Section 5 of the Federal Trade Commission Act. In fact, according to this section, the agency can take enforcement action against deceptive claims, and this could lead to prohibiting orders, and also the Commission has the power to seek civil penalties. In the US, consumers and NGOs are very sensitive to the issue of greenwashing, and we are seeing recent class actions especially on product carbon-related claims or operational claims, such as net zero claims. And as we said, there is an increase in the number of litigation in the US in 2025. Also, security claims are filed by investors who allege misleading ESG disclosures affected their investments. Basically, investors allege that companies have misrepresented the climate impacts of their products operation, thus causing the value of their stock to decrease. We know that under Trump's administrations, there has been a rollback of the climate disclosure rules, but we can still we can expect the traditional misrepresentation cases for securities litigation. In 2022, also a fine was committed for deceptive environmental claims on eco-friendly processes used in textiles by big retailers, while they required these processes the use of toxic chemicals and result in pollution. So the Commission has asked the court to order stop making the deceptive green claims and also pay the penalties, and these retailers have paid these penalties to resolve the allegation. Just states are moving a bit faster than the federal level, and I wanted to show you just, California here, because it has recently issued laws to protect against misleading environmental claims. We have 2 sections of the Business and Profession Code which outline the requirements of environmental representation, and they basically require that claims must be substantiated by competent and reliable evidence. And also, it is required to maintain records of the specified information and documentation supporting the validity of the representation, including, if applicable, whether the consumer good conforms with the minimum standards of the federal green guides. Senate Bill 343 has amended these two sections and imposes new advertising and labeling restrictions regarding the recyclability of products and packaging, and also the use of the chasing arrow symbols. So there are very stringent criteria, and all these symbols can only be displayed if these percentages and rates are met, meaning that the material must be collected by recycling programs covering at least 60% of the Californian population, and also accepted by recycling facilities of at least the same percentage of state programs. And also the material must be used as feedstock for new products packaging. And I wanted to mention this bill because there is a deadline. There is the deadline of the 4th of October. After this date, these symbols and the chasing arrow symbols cannot be used unless these criteria are met. Finally, I just wanted to mention very quickly the regulatory landscape in Canada, a country with a level 3 protection because has issued both binding rules and guidelines to support them. We have the amendment to the Competition Act effective from June 2024, and then specific guidelines which were issued in June 2025. The main two requirements are for product performance claims, which needs to be based on adequate and proper testing, and also claims on environmental benefits must be made in accordance with environmental recognized methodology. I wanted to highlight here that in August 2025, investors and stakeholders have called for a change of the current bill, as it could hold back environmental disclosures and lead to greenwashing. In fact, the requirement of having the claim conformed to international recognized methodologies is subject to different interpretation and is not clear to companies. Also, the guidance says that third-party certification is not required, but these methodologies often do, so this seems a bit contradictory. And also, as we know, the risk is greenwashing, so the practice of deliberately choosing not to hide or not to disclose environmental achievements due to the fear of not being compliant, and which is a practice that could lead to different issues, such as, among others, the risk of decreasing consumer trust and also lack of transparency, so something that is not advisable in the long term. Other changes advocated by stakeholders were the removal of private action, which was established by the amendment, and also the reduction of fines, which are very high. So the issue for companies, and not only in Canada, but worldwide, remains to understand the boundaries and limits of environmental claims information, and to know which criteria to use when substantiation is needed, depending on the type of claim and the jurisdiction in question. This concludes my part. Thank you, and I'll now pass it over to you, Anna.
Thank you, Emilia, for your overview. It was very informative. And I'll now move on to discuss some Asian countries where similar developments have occurred in recent years. I will start with South Korea. In 2023, South Korea became a regional pioneer in greenwashing regulation through two parallel initiatives. First, the Korea Fair Trade Commission revised its environmental labeling and advertising review guidelines in September 2023, focusing on environmental labeling and advertising with active enforcement of false or exaggerated environmental claims. And separately, the Ministry of Environment proposed an amendment to the Environmental Technology and Environmental Industry Support Act. These amendments aims to strengthen control over greenwashing. This draft proposes to establish sanctions up to 3 million won, approximately $2,000. And according to data from the Ministry of Environment, there were almost 5,000 greenwashing cases over 3 years from 2020 to 2022. And looking ahead, draft sustainability disclosure standards has been published in 2024 with implementation expected in 2026. These standards comprised mandatory public notification standards that companies must adhere to, and also some optional public notification standards that grant companies the choice of whether to apply them or not. And you can see that this creates the same reporting versus marketing consistency risk that we see in Europe with Corporate Sustainability Reporting Directive. The next country is Japan. Japan has no specific greenwashing law. The Japanese Unjustifiable Premiums and Misleading Representations Act is the core legislation on greenwashing for now. The Act prohibits two main categories of misleading representations. The first key prohibition is under Article 5.1. This is the one most commonly applied to greenwashing. It bans any representation that suggests your good or service has significantly better quality standards or characteristics than it actually does, or when compared to your competitors. The second prohibition is Article 5.2. It prohibits false claims about favorable price or trading conditions. In a greenwashing context, this would apply to misleading statements that exaggerate the financial benefit to the consumer from choosing your green product, such as false claims about utility savings or misleading statements about green products' price advantages. And in October 2024, Japan's amendments to the Act against Unjustifiable Premiums and Misleading Representations took effect. The key changes include straightened sanctions, so charge penalties up to 3% of sales for products or services with misleading claims. Also criminal fines up to 1 million yen for malicious violations, cease and desist orders, and mandatory preventive measures. And in 2022, Japan's Consumer Affairs Agency penalized two companies for falsely labeling their shopping and garbage bags as biodegradable. Let's move to India. India has developed a unique dual-track system that is now fully operational. Track 1 is the guidelines for advertisements making environmental green claims. These were published in February 2024 with a focus on advertising and marketing communications. Track 2 is guidelines for prevention and regulation of greenwashing or misleading environmental claims. These were finalized in October 2024 with a focus on consumer protection under the Consumer Protection Act. Both frameworks prohibit absolute terms like environmental friendly or eco-friendly without robust data or credible accreditation. It also prohibits casual use of green or carbon neutral without proper qualification, concealing, omitting, or hiding relevant information, and exaggerating or making vague or false environmental claims. The penalty structure is designed to escalate significantly. For a first offense, companies face fines up to $12,000 but for the next violations, that jumps to $60,000. And beyond monetary penalties, companies face mandatory discontinuation or modification of any misleading advertisement immediately. Now let's speak about China. China has no specific anti-greenwashing legislation as well, but uses existing frameworks for enforcement. The first mechanism is the advertising law combined with the anti-unfair competition law, which prohibit misleading commercial promotions. And the second mechanism is environmental information disclosure, where companies failing to disclose or providing false information face correction orders and fines. In April 2024, China issued the guidance on self-regulatory supervision of listed companies' sustainability reports, which requires the listed companies to issue their ESG reports on an annual basis, while other listed companies are recommended to voluntarily disclose the ESG reports. The guidance requires the information disclosed to be objective and true, and should not mislead any investors or other stakeholders. And we can see that in 2024, a company was sanctioned for promoting products as first choice for environmentalists without supporting data. This was a violation of Article 8 of the Anti-Unfair Competition Law regarding misleading commercial promotions. Moving to Singapore. Singapore takes a proactive enforcement approach using its existing legal toolbox. The current framework includes the Consumer Protection Fair Trading Act, enforced by Competition and Consumer Commission of Singapore. The next one is the Advertising Standards Authority of Singapore, which can require modification or removal of misleading ads. And just this month, Singapore released a new guide on misleading environmental and product claims. But it's important to say that it's a guide rather than a legislation. It provides a direction, but doesn't create new legal obligations. The guide was developed following concerns raised over potential greenwashing and recent enforcement actions against businesses found to have made misleading claims. The guide established 5 key principles that businesses should refer to when making product claims. Principle 1 is that claims should be true and accurate. The second one is that claims should be clear and easily understood. 3, claims should be meaningful. 4, claims should be accompanied by material information. And the last one establishes that claims should be supportable by evidence. The making of misleading or false claims by a business can be an unfair trade practice under the Consumer Protection Act, and it can result in substantial penalties. For investigation, obstruction, or providing false information, violators can face fines up to 10,000 Singapore dollars, or also imprisonment up to 1 year. And additionally, the Fair Trading Act provides civil remedies allowing consumers to sue directly for damaging or seek injunctions. And in conclusion, what we have seen so far is that greenwashing is no longer just a reputational risk. It's becoming a serious legal liability. The regulatory landscape is evolving very rapidly. Therefore, monitoring is crucial. It's very important also to provide information when asked and not only reduce risks, but to create business value under many aspects: consumer trust, investors' confidence, and procurement. The main risks associated with greenwashing are the first one is damage to corporate reputation. Companies face increasing scrutiny from consumers, employees, investors, and suppliers. The second one is legal and regulatory risks. Companies expose themselves to the risk of regulatory non-compliance and investigations, administrative enforcement actions, and financial penalties. And also, there is a potential lawsuit risk. So companies risks to litigate from litigations from consumers, competitors, activists, and regulators globally. And what the company can do to avoid these risks? We provided 6 steps to greenwashing risk management. The first one is mandatory training and upskilling. Build a culture of compliance and transparency. Upskill all relevant teams, including board members, employees, and agency partners on core ESG criteria and brand-specific greenwashing risks. Raising awareness and knowledge ensures informed decision-making aligned with sustainable practices and regulatory requirements. The second step is continuous regulatory monitoring. Given the growing complexity of regulation, continuously monitor the evolving regulatory landscape to identify emerging changes and understand their potential business impact. Proactively adjusting practices reduces the likelihood of non-compliance and associated greenwashing risks. Step 3, mapping all green claims. Identify every instance where your business make a sustainability claim. This includes marketing and product information, third-party supplier marks and certification, ESG sustainability reports, including material impact assessment. Step 4 is screening and risk management. Assess and mitigate risks. Conduct a screening to identify potential sources of greenwashing risk and perform a gap analysis of current processes and policies. Review existing green claims against verification requirements and common pitfalls. Ensure all ESG disclosures are clear and transparent. Review third-party contracts to ensure alignment and access to necessary data. Step 5 is adopt a proactive compliance strategy. Establish a robust control environment. Update governance processes and policies to incorporate formal risk management and control procedures. Adjust processes for the creation, approval, and verification of all claims. And step 6, preparing for litigation. Acknowledge the rising number of lawsuits related to expanding ESG disclosure obligations. Companies must proactively manage risk associated with potential litigation by ensuring accuracy and defensibility in all public statements. That's all from me. Thank you for attention. Back to you, Orla.
Brilliant. Thank you, Emilia and Anna, so much for your informative webinar. A lot of great information there. And Thank you all for your attention so far as well. We've had plenty of questions coming in during this session, and the floor is now open for this Q&A session. So again, just a reminder, if any of you have a question that you would like us to answer, please let us know using the Ask a Question widget to the left side of your screen. And yeah, as I said, we've had a good few coming in already, so we'll answer some now. The first one, what is the scope of Californian Bill 343? Which products does it apply to?
I can take it, Orla, thanks. Since I covered it during my part. The scope of the Californian Bill 343 is very broad. So it basically applies to any products and packaging with so very, very broad. And it is not only about which product and packaging are in scope, but it is very broad also in terms of the symbols which are in scope. So it is not only about the chasing arrows symbols, but it also concerns any other type of recyclability information on the product or packaging, which cannot be used after October 2026 unless the stringent criteria for the collection and the sorting percentage rates above 60% of the material are met.
Brilliant. Thanks, Amelia. Next question. Do greenwashing regulations differ in Hong Kong from mainland China?
I will answer this question. Actually, yes, greenwashing in Hong Kong differ from mainland China due to distinct regulatory frameworks, but both face enforcement challenges. China's approach relies on general advertising and anti-unfair competition laws, while Hong Kong uses existing ordinances like the Trade Descriptions Ordinance and has regulators.
Great. Thanks, Anna. Third question. Are there other EU member states where enforcement has been high?
I can take it. Yes, the answer is yes. I only covered France and Italy of course, we have time limitations, but I can mention other EU member states where enforcement has been strong. Germany, for example, and also the Netherlands and Poland. I can recall some recent disputes that I read in the last few days. And also the Netherlands is another country where there are specific guidelines on sustainability claims, and the enforcement authorities are really using these guidelines to support their investigations.
Great, thanks, Amelia. And just based on the time, this will be the final question we cover during the live session today. What is the most reliable piece of information a consumer should look for to counteract greenwashing?
I can reply. The most reliable will be independent, verified, third-party certification from a reputable organization like Fair Trade Label or USDA Organic Seal Certificate. And this moves the environmental claim from the company's marketing department to third-party audited source.
Brilliant, great. Thank you both so much for that. And as we're close to the top of the hour, I want to Thank you all for tuning in with us today. We hope you found today's presentation helpful and look forward to seeing you in our upcoming webinars. You can check out our resources section on the website to stay updated and to access our latest white papers, blogs and webinars, both upcoming and on demand, where you can watch it at your own pace. But in terms of upcoming webinars, keep an eye out for our next webinar scheduled for the 19th of November, Medical Devices in the Age of AI and Cybersecurity, Regulatory Insights. And again, that is scheduled for Wednesday, the 19th of November. So we hope to see you there. Thank you again to Emilia and Anna for that fantastic presentation. And thank you all for joining us today.